Live from the Glasgow Electric Plant Board, Glasgow Wants to Know. With your host, Mr. Uhel Barrickman.
The Glasgow Electric Plant Board and WCLU welcomes you to the last in the series of interviews with, live interviews that is, with candidates for the various offices in Barren and Metcalfe County. The election, of course, will be held the 2nd of November, and we urge everybody to vote. Tonight we have as our guest the candidates for Circuit Judge, the sitting Judge, Carroll Redford, and the sitting District Judge, Judge Dickinson. This office for which they are running is probably the most important office in the county, in that it is the place where the initial determination of disputes between citizens within the county and between the citizen, our citizens, and their governments are first determined. And it is this office that first determines property rights and liberty and often life. So it is a most important office, and for that reason I think you should pay close attention to the various views that you may hear expressed tonight by the two candidates. And first, Judge Redford, would you give a brief history of your background, your education, and your occupation to date?
I'd be happy to, Uhel. I appreciate being here tonight to speak to the voters of this circuit, Barren and Metcalfe counties, and I would appreciate the opportunity to be able to give that information. I was born here in Glasgow, and I've lived here all my life. I was educated in the Glasgow schools and Kentucky Military Institute, Vanderbilt University, where I received a degree, and then to the University of Kentucky College of Law, where I received my degree as an attorney. It was an LLB degree converted to a JD degree later. I returned to Glasgow after acting as a clerk of the Court of Appeals. At that time, it was the highest court of the state. I was appointed to a term of 1 year. And after serving as clerk of the Court of Appeals, a law clerk there, I came back to Glasgow to practice law with my father, Carroll Redford. I returned to Glasgow in 1960, and after practicing here a few years, I was elected judge of the Glasgow Police Court, where I served 4 years, and then Barren County Attorney, where I served 12 years, that's 3 terms. And did not seek re-election to that office. And in 1979, I became Commonwealth's attorney here and served 14 years as Commonwealth's attorney until recently, a few months ago, when I was appointed circuit judge, where I'm serving now. That position became available and open when Judge Shelley T. Ryherd retired. And the Judicial Nominating Commission sent my name along with other attorneys to the governor who appointed. And then it turned out that at that time it was necessary to file for the office in the November election, and we are on the ballot in November the 2nd. And we're here tonight to discuss that.
Judge Dickinson.
I am a Glasgow native. I graduated from Glasgow High School in 1960. I was second in my class. I had an academic scholarship to Center College at Danville, Kentucky. And after graduating from college, I was in the Navy. I joined the Navy when I was a freshman at Center, and went in the Navy for active duty for 3 years and served aboard the heavy cruiser USS Newport News. After I got out of the Navy, I got off of active duty. I went to the University of Kentucky on the GI Bill and graduated. I was in the class of 70, but I actually got out in December of 1969. I finished in 2.5 years instead of 3. I graduated 6th in a class of 115. I was on the editorial board of the Kentucky Law Journal, and graduated with honors, Order of the Croix, and came back to Glasgow and joined the law firm of Richardson, Barrickman, and Dickinson, where I was for 8 years, and I became a partner. In '74, I ran for and was elected city prosecutor for the city of Glasgow, and stayed city prosecutor until I ran for district judge the first time when the district judgeship was created by the constitutional amendment in 1975. I chose to run the first time in 1977 and was elected unopposed for 3 terms, and then elected for the 4th term 4 years ago, and am still a sitting district judge. I'm the only district judge that Barren and Metcalfe County have had since the initiation of the system.
Now, both of you gentlemen have had experience of observing and practicing for, and at least both of you now having sit as a judge, either in a lower court or in the circuit court. Each of you, as a result of that, have acquired a judicial philosophy. By judicial philosophy, I mean a philosophy as to what you think a judge should do and how he should do it and what his functions are. Judge Dickinson, please tell the audience your judicial philosophy.
Well, I don't know whether I can put that in a few words or not, Uhel. I can try.
If you get too long, I'll stop you.
I guess that you would. I think the question that you're asking is, what does it take to be a good judge? And in my experience, it takes a whole lot more than being a good listener to be a good judge. A good judge first knows the law and applies it fairly across the board to everybody that comes in front of him, no matter what their position or what their politics. And he applies that law fairly and evenly, and even when it's not good politics. A good judge is innovative. A good judge does things to make the system work better. A good judge sets the standard for the court system. That is, if he is hardworking, everyone in the system will be hardworking. If he is punctual, everyone in the system will be punctual. He treats everyone fairly and courteously who comes before him, and expects everybody else to do the same thing. That is, you don't make parties and witnesses and attorneys sit around all day not doing anything. You keep the court system moving. A good judge is concerned about the victims of crime and takes care of the damages that they suffer as a result of criminal conduct. But mainly a judge knows the law and applies the law fairly. That would be my judicial philosophy.
Judge Redford.
I think my judicial philosophy is that the concerns of the litigants, the people involved in the lawsuits or in the criminal cases, are handled fairly, of course, but competently, that they are represented correctly, that their lawyers are handling their cases in a manner that is proper, but yet that the judge stays out of the middle of the case, that the lawyers and the litigants bring to the juries or to the court the issues that they have. And in doing so, I think the judge needs to be a person known to be fair and impartial, one that when the parties come to court, they know they're going to have their day in court, they're going to have a fair hearing, and they're going to leave knowing that they've been able to have their say as to what their problem is, or what their defense is, or what their claim is. And one of the problems that we have in the court system is that of time. I think sometimes it is tended to be rushed, to not let the parties have their say. But within the framework of the rules of the court, a judge must be compassionate, yet firm. He must make fair decisions, and above all, when the parties come, they know he's going to be impartial and hear their case.
Gentlemen, I have had people ask me questions about each of you. I've overheard talk about each of you in this campaign. I have purposely refrained from answering questions about each of you because of this and other reasons. But based on what I've heard from lawyers, what I've had lay people ask me, based also on some implications which you gentlemen have run in ads without saying specific things, but certainly implying certain things, I'm going to ask you a series of questions. The one question that I have heard most applies to both of you, and that is why, with each of you having been nominated for an office and having no opposition in the election in November, you each decided not to run for that office and gave it up and instead ran and are running for circuit judge. And the public out there wants to know from each one of you, I think, what it is about the circuit judgeship that each one of you is so interested in having. I'll let you answer first, Mr. Dickinson.
All right, I'll be glad to answer. It seems that that question is asked of me more often than it is of Carroll, and I really don't understand that. He did give up a 7-year unopposed term as Commonwealth's attorney to take the appointment from the governor as the circuit judge. That was a political decision made in Frankfurt, and I, being a judge for 16 years by code of judicial ethics and by statute, I'm not allowed to be in partisan politics, so I was not surprised that I did not have any political clout to be named as the governor's choice for the circuit judge. I decided 16 years ago on a judicial career. That was in 1977. I ran for district judge the first time and ran unopposed, if you recall, because nobody else wanted the job. I've been the district judge for 16 years. I've watched that judgeship and your court, your district court, grow from about 5,000 cases a year to about 8,000 cases a year. It is the 4th busiest court in the state. I decided on a judicial career, and in the next logical step for that judicial career is the circuit judgeship. I filed for circuit judge 2 years ago and withdrew my nominating papers shortly after the deadline because Judge Ryherd indicated publicly that he wanted a couple of more years to fill out his retirement, and that I didn't mind waiting a couple of more years, but I announced at that time that when he did retire that I was going to run for circuit judge, and I don't think it should have surprised anyone that I did run for circuit judge. My consideration was that I'd been standing in line for that position for 16 years, and it was my turn, and I thought it was my turn to announce and run for circuit judge, so I did.
Judge Redford.
I accepted the appointment because I was convinced by others that I was the best qualified person and that I should do so at this point in my life. My age, my trial experience, and my background and training was such that I probably had more actual trial experience in circuit court than other lawyers in the area. At the moment, both criminal and civil, because I'd been Commonwealth's attorney for 14 years and a trial attorney for 33 years, doing civil trials of all types. I canvassed the various attorneys and judges of the area, friends of mine in other counties, to know about them moving to the bench, and decided that it was time for me to make that change if I was ever going to do so. I think that my background and experience as a trial attorney of 33 years, doing all types of work, and the Commonwealth's attorney doing all of the felony criminal work in the circuit court itself, qualified me especially for this. I have served under Judge C.R. Walden and Judge Shelley T. Ryherd for the last 14 years, and besides that judge, I am the person that has spent most time in circuit court. This is an election for the circuit judge, and it's not unusual that the Commonwealth's attorney moves from that position to the judge's position in circuit court. Likewise, the U.S. attorney moves many times to federal judge because they have the most trial experience, and for that reason I elected to do so at this time.
Now, the next series of questions that I'm going to ask, one applying to each one of you, is some questions that I've been told that I wouldn't ask because I'm going to have to practice law before one of you. I don't know which one yet, but I'm going to have to practice before one of you. But nonetheless, I'm going to ask the questions. And again, the first question to you, Judge Dickinson.
Why do I get to go first all the time, you? Go ahead.
Maybe it's because I just want to pick on you
Yeah, I know.
tonight.
All right, go ahead.
Of course, you have had ads out there about the number of cases you've handled over the years, how efficient your court is run, and have dealt in a matter of statistics. And he, by implication in an ad, has indicated that you're more interested in statistics than you are in capabilities of being a judge, or at least that's the way I read his ads.
That's the way I read it too.
He hasn't specifically said that, but that's the implication. And along with that perception is the idea that you're more interested in clearing a docket and keeping a docket current. And as a result of that, you sometimes make up your mind before you hear everything you should hear in a case and don't have an open mind, and that you come across as an arrogant individual on the bench at times. That is out there, whether you are aware of it or not. I presume you probably are. What's your answer?
Well, let me put it this way, Uhel. If you don't have any judicial experience, you've got to say something else to make up for a lack of judicial experience. And calling yourself a people person is not a substitute for judicial experience. I have the same kind of qualifications for community involvement as Carroll does, and it has absolutely nothing to do with judicial experience. The implication was that I was too interested in statistics. I want to guarantee you that if Judge Redford had any statistics to back up his qualifications to be circuit judge, he'd be spouting them day after day. He does not have that experience, so he can't use that. He's got to make up for that some other way, and the other way that he does that is to say that he is a people person, or he's a good listener, or he's had experience as police judge in the city of Glasgow, none of which qualifies anybody to be circuit judge, which you correctly call the most important job in this county and in Metcalfe County. I accept some of the criticism of me that I do move quickly. When you have a court that's got the fourth busiest caseload in the Commonwealth of Kentucky, you've got to move things. And if you let the lawyers run your court, you never would get anything done. You have to set cases for trial and demand that they be tried on time and not accept every excuse in the world for delaying something. I can guarantee you, though, that I have never decided a case without hearing both sides fully, and I have not heard that criticism, whether you have or not, of anybody ever saying that I decided a case before I heard the evidence, because I have not done that. Now, the most that I have heard, and the most often of what I have heard, is that I don't care what you say about Benny Dickinson, you know that when you're in his court, he listens to both sides before he makes a decision, and it doesn't make any difference who you are, or what your social position is, or what your politics are, or what the color of your skin is. He decides the case based on the merits of the case, and that's all. And I have not heard the criticism at any time in my judicial career that I've ever decided a case. And I take that back. I have heard that criticism since this campaign started, but never before. And I think it's a result of this campaign, and I don't think it's justified when it is said.
Well, what I'm hearing and what I'm asking about is what I'm hearing now, not what I may have heard years ago. I'm talking about what I'm hearing out there from various people insofar as the campaign is concerned. Now, Judge Redford, the criticism that I hear from you and or about you, and it is a criticism, is first of all that you're a politician instead of a jurist, and that you are also a procrastinator, and that it takes you a long time to get things done. And some of the criticism has been that I have heard in that you tried to do too much and had too many things going at the same time and couldn't tend to all of them with the degree that you should have. What is your response to that?
Well, with reference to the business of doing too many things, it may well be that we do too many things. I don't know. I know that I probably spend more time working than most people, and it's well known around town that I get up about 4:30 or 5 in the morning, go to my office, start working, do 2 or 3 things, 2 or 3 cases, work all day, and sometimes, many times, come back and work at night. All of that is on the law primarily, and if that is doing too much, that's possible. However, I've been doing that schedule for many, many years, and I feel like the work ethic is an important thing. No matter whether you're farming, whether you're milking cows, whether you're working at the factory, you have to be on the job, and I think everybody in town knows that I have been on the job. As a public official, I've always been available. Everybody can get in touch with me. I think you know, Uhel, that I'm where I'm supposed to be. I'm in my office or in the courthouse. I'm working on my cases. That's not so with some people. You can't find them. When you need something, they can't be found. I've been available to the police as a prosecutor, the county attorney, or the Commonwealth's attorney, writing search warrants, doing all of those things. And I think that that is my background, and that is the basis for my work. Now, as that moves into the realm of being a judge, I think this is one of my strong points, in that I have done, I'm the only candidate in this race that has sat in every seat in the courtroom, both plaintiff's attorney, defendant's attorney, a lot of insurance defense work, have been prosecutor, county attorney for 12 years, Commonwealth's attorney for 14 years, the last 14, the latest 14. And therefore you have more experience than others, and that is one reason for the selection of being the judge, because I have been there doing the job, doing the work. I don't think that there's any procrastination there. I think the lawyers can tell you that we've tried all the cases. They have not been delayed in any way, and as a matter of fact, in about 1985, I had the highest caseload per prosecutor of any prosecutor in the state of Kentucky, and at the same time, statistics showed that I produced those cases at the least cost, and so I have a good record of working.
Well, the basic criticism, of course, is that insofar as both of you is concerned, that he's too quick, going to be too fast, and not going to listen enough, and that you're too slow and going to take up too much time. And that's out there. That perception is out there as far as both of you is concerned.
Well, if you take that as being a given, I think that those who know anything about court know that they would rather have somebody that is careful and considerate of the case as opposed to one who's quick on the trigger, because you don't hear all the facts, you don't know all the evidence, you don't consider it. I think if you're going to err either way, you should do it on the consideration side as opposed to merely moving cases by numbers.
Judge Dickinson.
When you have a large caseload like I've had for 16 years, you must move cases, and you can't sit on them and procrastinate at all about any of them. You've got to move cases, and you've got to move them in and out. Now, that is in district court, and we're not handling life and death matters in district court. We're handling a lot of cases, and if you want to see cases moved sometime that really get moved, go to Jefferson County sometimes and watch them move about 400 cases in a 2-hour docket up there. That doesn't happen down here. We take more time. I talk myself dry in the mouth with defendants in front of me explaining their constitutional rights and doing all those kind of things. But I guarantee you the biggest criticism of the judicial system in this state is whether or not people get in and get their cases heard and get out. Not that they go to court 4 or 5 times and have cases delayed for 9 or 10 different reasons. Not that they sit there all day and don't do anything while the lawyers are back in the back room talking. When that happens, that's the judge's fault. And if it doesn't move like it ought to, it's the judge's responsibility. And I think Carroll has the reputation among the bar as being a procrastinator and not moving along on cases. And maybe I've got the reputation among the bar that I move too fast. But I don't think that there's any criticism of me that somebody is not treated fairly. I just move a lot of cases because I have to move a lot of cases. That's the nature of the situation that I'm in. A whole lot of cases come up. I've got to move a whole lot of cases.
Regardless of which one of you is elected, you're going to have a master commissioner. You, of course, have a master commissioner now, Judge Redford. I presume that Bobby Richardson's still master commissioner. I haven't seen anything to the contrary and haven't had any reason to find out. But have you selected, in the event you are elected, to finish out Judge Ryherd's term, have you selected the master commissioner, and if so, who is he?
No, I have not. What I have done is I have not made any changes from Judge Ryherd's appointments of anyone. Master Commissioner being one. Bobby Richardson is the Master Commissioner, has been that for a number of years. I have not promised him or anyone the job of Master Commissioner, and that'll be decided after the election. I thought that it would be imprudent to make any changes for the few months that were available there in any of those positions, commissioners, domestic relations commissioners, or otherwise.
I assume that's true of Metcalfe County as well as Barren.
That's correct.
Have you made a selection for Master Commissioner in the event that you're elected, Judge Dickinson?
No, I have not.
Now, you mentioned the domestic relation commissioners. And I do want to ask you a question or two about that, the two of you. There are now two, one for Barren County, apparently, and one for Metcalfe County, although I understand, and as you know, I normally don't do the divorces, but I understand that the one in Metcalfe County also handles some cases in Barren County.
That's correct.
Now, my question is this: is it necessary to have two?
It may or may not be. When I took office, we had two, and it permitted, as it appeared to me, that it would eliminate conflicts. We have various people that are related to each other, that are in the legal system, that are lawyers, and then we have times in which there is a claim that the commissioner has some relationship, business, financial, or otherwise, with the parties, or otherwise they claim that they should have a person more disinterested because of whoever the commissioner was. So that does permit a substitution of the commissioners. It has worked out nicely. The Supreme Court Chief Justice approved retaining it like it is for the time being, and so I don't have any plans on making a change as far as the numbers. Possible that other people would be the domestic relations commissioners. I'm going to decide that after the election. I'm trying to make the employees of the court, the master commissioner or the domestic relations commissioner, not a political pawn to toss around to gain votes or to do anything else. We're just trying to keep it on an even keel, and after the election I will decide the proper parties for those positions.
Do you think you need two?
No.
Judge Dickinson?
No, you don't. One's plenty, and if the one that you have has a conflict, then you do the job yourself. You don't refer it to a domestic relations commissioner, and one is plenty for this court. There's no need in the world to have two domestic relations commissioners.
Now, while we're on the subject, suppose you explain, Judge Redford, just what the domestic relations commissioner does.
Be happy to. The commissioner is another judge that has authority to do certain things, somewhat like a trial commissioner in the district court. It assists the judge. The the domestic relations commissioner will hear evidence in a divorce or domestic case, and he will make findings. Sometimes those domestic cases go on for long times, days at a time, gathering facts about the person's property, all the details. Maybe they have a custody contest where they bring in psychologists, psychiatrists, social workers, others, and it takes a long time to hear that. If a commissioner is hearing that and making findings, that leaves the court free for other trial work going on at the same time. And so in that way, the commissioner makes findings, just like a master commissioner might make findings in other types of cases. Return those to the judge, who then either approves them or makes other rulings that if any of the parties object to the findings that are made. It makes a smooth operation for the court and probably moves cases along faster.
And they are paid, are they not, by fees that are taxed as part of the cost in these domestic relation cases, principally divorce cases?
That is correct, and those fees would be maybe $20 up to, I've seen some as high as maybe $300.
Now, in some courts, and I think also until the time Judge Walden retired, that most of your domestic relation cases, and particularly divorce cases, were handled by depositions rather than through a domestic relations commissioner. Judge Dickinson, have you any preference for one system over the other? I take it that you could still use either one, because I do know of some judges in other circuits that are still using the depositions rather than having a domestic relations commissioner.
I think a domestic relations commissioner is a good way to do it. I just don't think that we need two. I think it's better to have someone sitting there who is a commissioner that see the witnesses when they testify, because then you can tell that you can gauge their credibility. You don't, you're not looking at a sheet of paper and reading testimony, and that's always a problem when you do something by deposition. So I'm in favor of having a domestic relations commissioner, and only if he has a conflict, which would be rarely. If he came up with a conflict, then the circuit judge himself could do any conflict case. But I would say, yes, have a domestic relations commissioner and let him see the people face to face and judge their credibility and weigh the evidence that way. It's better than just reading a cold record, I believe.
Another innovation in one sense that's going on these days, there are more and more cases of notoriety that are being televised. There is even, as I'm sure each of you gentlemen know, a court channel. We don't have it here in Glasgow, but there is a court channel that televises important cases all over the country. They televised this General Motors case, for instance, down in Atlanta back in January and February, which resulted in that substantial verdict against General Motors for punitive damages. You, Judge Dickinson, already permit the televising of the small claims court in your court. Now, in the event you are elected as circuit judge, and there is a criminal case or any other type case that has considerable notoriety in the community, would you be willing for it to be televised, or would you oppose it?
I'd be more than willing to have it televised. The rules changed in June of 1981. The Chief Justice changed the rule to say that a presiding judge could allow cameras in the courtroom. Before that time, it was not allowed. On the very first day that cameras were allowed in the courtroom by the change of the rule by the Chief Justice, which was June the 30th, 1981, Judge Walden and I signed a joint order at that time allowing cameras in the Barren Circuit Court and the Barren District Court without exception, and we signed the same order in Metcalfe County, with the only exceptions being in district court, of course, you cannot film juvenile matters because they're confidential. We made that exception. And we made an exception for any interested party or witness or attorney for cause shown or on the court's own initiative could disallow the cameras in the courtroom for a specific case. I think it is a valuable tool, a very valuable tool to educate the public about what's going on in court. They ought to know what's going on in court, and they ought to see what's going on in court. And I don't know why we should deny the technology. The district court small claims docket is done in a very primitive manner. That is, we just set up a camera on the end. The people from the electric plant board set up a camera on the end of the bench and just film us while we're talking at the bench about small claims cases. It could be done much more sophisticated than that if we had the money. I've suggested to the electric plant board that they maybe spend a little money and have some better cameras and sound-activated cameras and that kind of thing like is in circuit court. But in circuit court right now, we have sound-activated cameras and the whole system is video anyway. And it would be a very simple technological procedure to transfer that to a television channel to broadcast it as we would, and it wouldn't hurt a thing. There is no fear of, I have not seen in court the fear that some people name that people parade for the camera or try to act for the camera. I haven't seen that at all. And as a matter of fact, people behave better when the cameras are rolling as far as I'm concerned. But I think it's a very valuable tool, and I would be more than willing to use it as on a case-by-case basis. But we have the rule, and it's been in effect for over 12 years right now. And it was very good when we had it in effect, for instance, when we had the Amish case that everybody wanted to see, when we had that Ku Klux Klan thing that everyone was interested in. It was very orderly done in the district court. There were 5 television camera crews in the hallway outside of my court. Only 1 was allowed in the court, and we had it organized in such a way that they all got their video from one different one, and we have a pooling arrangement when that occurs. And it was done very orderly because we had the mechanism in place for that to be done. But cameras in the courtroom have been going on for a whole lot more years than the last 12 years in other jurisdictions, and I see no harm in it at all.
Judge Redford.
I think you know me, Uhel, that I appreciate high technology. I've been involved with photography for years and video equipment, stereo equipment, various things. I agree with Benny that I don't see anything wrong with video cameras in the courtroom under the circumstances that the Supreme Court rules permit. The issue that I am thinking about, and I would want to be cautious about, is that in district court they're trying traffic tickets, they're having small claims, people owe somebody $50, things of that nature, and it is of interest because it's short. You can get the issue over. It's like a soap opera. You can get it all in just a few minutes, and that's it. In circuit court, where I'm presently the judge and where I've practiced for 33 years, the concern I have with completely videoing that all the time is that the cases, we have child sexual abuse cases, we have murders, and I think you know I'm the prosecutor that's tried the only death penalty case in this jurisdiction maybe for 60 years. That was upheld by the Supreme Court. You have a lot of ugliness, you have gore, you have violence, you have sex, you have nasty words that come out in the cases. I have some concern that a routine program of that would pump into somebody's home this sort of thing without their consent. And when I say without their consent, their children can go in and turn it on and get that. I think the circuit court cases are such that you would have to do it on a case-by-case basis. There would be some that would be of interest. If you had a high-profile case, then that would be something you would want to look at. But routinely, we have rapes and gory murders and many cases that have very nasty words that have to be spoken in order to show the jury exactly what happened at the time of the crime, for instance. Now, there are civil cases that might be of interest to the public also, and you'd want to look at those to see if they would be broadcast, such as like you and I were talking earlier about pickup truck gasoline tank explosion, something that you see in the news and the public might be interested in. I do know that Attorney General Janet Reno just yesterday said that the television industry, the movie industry, is going to have to clean up its own act about putting into homes of people violence, acts of perversion, goriness, things of that nature. And so I think the judge should in some way control that, and if it is broadcast, it would have to be selected to protect the participants, the parties, and have a reasonable and suitable program. But I am in favor of permitting it. As you know, the Barren Circuit Courtroom is one of the early video-equipped courtrooms. Judge Shelley T. Ryherd was instrumental in getting the courtroom changed from court reporter system to a complete video audio system. There are 5 cameras installed in the courtroom, and the clerk runs the entire system with a console, and everything is on videotape, every conversation, every act. And it has been extremely helpful to the court system, because when you get finished each day, the record is made up. You can have a copy of the record. If you want to appeal, it's very inexpensive. You can appeal using that videotape, and it's possible to connect that right to the local cable system. And that would show. Also, the cable system might want to use its own cameras. I don't know, whatever would be interesting. I know that circuit court trials are long and involved and technical, and they do not produce the excitement that a television show like Perry Mason does, where you can cut away and have a commercial. But generally, I think it would be a good thing in selected cases.
As both of you know, up until Judge Ryherd became judge, we had rule day on Friday. Now we have it on Monday. I've heard some criticism of the change. Do you propose, Judge Redford, to leave it on Monday? Or you thinking of maybe moving it to some other day?
I think rule day for the listeners here, that happens to be a day when lawyers do business. It's not a trial, but it's where you have motions or things to bring before the judge that are necessary in the preparation of your case.
And you have a lot of the public that has to attend.
Yes, like maybe involving divorces or other cases that are there, so that the public is there. Mondays have seemed to work well. I have not changed it from what was going because the lawyers seem to like it, and we didn't find too much difficulty. This is the only circuit that I'm aware of around here very close, at least most of them that we were discussing, do not have a rule day every Monday. We have a rule day every week in both Barren County and Metcalfe County. Most of the adjoining counties have only a rule day every month or so, so that we have the opportunity to get more business done here quicker for the litigants than many of the other places. I think it's merely whatever is the convenience of the lawyers primarily to get situated as to what day of the week you have it. One reason I think Judge Ryherd liked Monday was that it permitted you to have all those motions taken care of on Monday in both counties, and that left Tuesday through Friday for jury trials, so that if they lapped over, you had 4 days going there. I think it's just what you want to do. You could have it on Friday or any other day, but I think either a Friday or a Monday is best to leave as many days together as possible for jury trials.
Judge Dickinson.
I think I would ask the bar what they thought was the most convenient to their schedule, and then schedule my court accordingly.
I am hearing complaints from lawyers and also from some lay people in adjoining districts. This hasn't happened in our district, but in at least 2 of the adjoining districts, about the circuit judge holding trials late into the night. And I understand there was one in an adjoining district where the jury finally made a decision at 5 a.m. in the morning. and that's going on in 2 adjoining districts. Do either of you, if you are a judge, propose to hold court up until midnight or after midnight and keep a jury there and the lawyers there all that time? Judge Dickinson.
No, I don't. I've done that in district court before, that we've gone past quitting time, and every time that 4:30 being the normal quitting time for jury trials, and every time that I've done that, we have been in the midst of a trial. I have asked the jury, do you want to finish this today or do you want to come back tomorrow? Every time they've said, I want to finish it today, we don't want to come back tomorrow. For that reason, we've gone as late as 7 or 8 o'clock a couple of times, and we've gone as late as 9 o'clock on one case in the last 16 years. But every time that we did that, I asked the jury, do you want to go home and come back, or do you want to stay and decide this? And I asked the attorneys and the parties, and every time it was a unanimous decision, we want to get it done today and come back. Now, in a case, in a circuit court case, you'd have a little bit different consideration, because you would probably be in a bigger case, and you could be able to judge better whether you're going to get through at 7 or 8 o'clock or not, and what you'd be able to ask the jury that, but and the attorneys and the parties. But just to go and go and go till 5 o'clock in the morning just to get a case done is, of course, nonsense.
Judge Redford.
I think that the length of a trial day has to be judged by the stamina of the parties and the jury. Usually we quit about 4:30 or so in the afternoon. I have had one trial that went into the evening, as Benny says, because the jurors, the litigants, and the lawyers wanted to go ahead and try to finish, and that was a recent case where I think we went to 9 or 10 o'clock at night. But all the parties and all the lawyers were from out of town, and the jury was willing to do that and thought that that was the best thing to do. It was a several-day trial, like most circuit court trials are, more than a day or two, maybe into the days and weeks. So you have to judge the physical condition of everyone. In circuit court, I try to let the jury have a break about every hour or so, and try to be very sensitive to their needs, because it's difficult for them to sit. The lawyers are walking and talking and moving and doing, and so are the witnesses, and we sometimes as lawyers forgot the convenience of the jury. But as judge, I am trying to be very sensitive to the needs of the jury.
There are some courts now that have rules that permit the taking of depositions over the telephone. And the only way you can prevent that is to file a motion and object, and then it's left to the discretion of the judge. Are you, Judge Redford, in favor of that?
Depositions by telephone?
Yes.
Yes, I'm in favor of it. As I told you, I'm sensitive and appreciative of high technology, and I see that this is one way that we can speed things along. We've already had something like that come up, and I have taken depositions by telephone before as an attorney, and I know you have. In some cases, depositions by phone are very helpful. Many times the witness is only going to talk about one thing. It's rather short, and sometimes the lawyers are in different cities. Sometimes it's a physician that is difficult to take a deposition from, or can be an elderly person or someone in the hospital, and it permits us to do those things. Under the constraints of the rules for taking those type of depositions, I think it's a good thing, and I'm sure it's here to stay.
Judge Dickinson.
I'd be in favor of that. I've allowed depositions to be taken by phone in my court. It's generally done when you want to take the deposition of an expert witness. They're usually short. If there's an objection by either side and they show cause why it should not be done by telephone, I would certainly listen to a motion like that. If you wanted, for instance, to see the witness face to face to gauge his credibility, then you wouldn't want to do it by telephone. But that's usually not an issue, taking the deposition of an expert witness, and I'd allow that to be done by telephone.
There is one court, circuit court, that I know of in the state that has a pilot project that is approved by the administrative office of the court, which permits the judge to order mediation in a case. And of course, you have much criticism these days about alternate dispute resolution forms, and there's more and more people clamoring for them. Would you favor a pilot project, Judge Dickinson, for such a rule?
Yes, I would. I think the evidence is in for those jurisdictions that are trying out mediation as an alternative dispute resolution process, that the evidence is in that it's working well. And it's not forced upon anyone. The parties are asked in the pilot projects that I know about, do you want to take this case to a mediation board? Do you want to try an alternative dispute resolution process? And when they agree, it's done by mediation. I think it's a good idea, and it saves the courts some time. And people, I think the evidence is in that people are pretty well satisfied with it, and it moves some cases along.
Judge Redford.
I see nothing wrong with trying that. I'm willing to try anything that the Supreme Court has approved for us to do by their rules. I think mediation is a way that we can move cases out of the court. Many times it really requires that and not a trial. And so as far as whether I'm willing to look at it or not, I certainly am. I'm always willing to try new things that are approved, so long as the litigants have their day in court and their rights are preserved.
Gentlemen, we have about 8 minutes left. I'm going to give each one of you 4 minutes to tell the audience and the people of the two counties why you should be elected and your opponent should not be. Judge Redford.
Thank you, Uhel. I appreciate the opportunity to come here to see the voters tonight and have them hear us talk, hear us answer questions, because this is a very important election. We have an election there for circuit judge, as Mr. Barrickman said, probably the most important position in the government system here, because the judge of the circuit court is the person who preserves the rights of all the parties, the person who conducts the trials that most people cannot appeal from. It's the person who needs certain traits, certain characteristics that will make it known that when you go to that court, you'll have your day in court before a fair judge. I think that this is an important election, and I know the folks that are listening in are doing so because they're trying to make up their mind. Who should they vote for? I'm asking you in the audience to vote for me, Carroll Redford Jr., for Circuit Judge of Barren and Metcalfe counties, because I have more trial experience. 33 years as a civil and criminal trial attorney. I have practiced in circuit court almost exclusively for those years. I have handled about every kind of case there is. I know that case and how to prepare it, and as a judge I will be sensitive to the needs of the lawyers and the litigants. I think that it's just like working anywhere. If you haven't done that job, you cannot very well understand what is happening. I think that I am not only the most experienced person with the right kind of experience, that's the experience of doing it, and also being a judge of the police court for 4 years, and now judge of the circuit court. I have the judicial temperament and the personality necessary to try to reduce the stress and anxiety that the parties have. You know, in circuit court, there are big issues. All of the major cases of big money are there in that court. All of the criminal cases are there. After a person has been indicted, the penalties are severe. They could go up to death, but certainly they are penitentiary sentences. And so the judge needs to be experienced, the right temperament, and also I'm the only candidate that has ever worked with the grand jury. The grand jury is an integral part of the circuit court. I have been working with them for many years as county attorney and as Commonwealth's attorney. For those and many other reasons, I'm asking the voters to elect me as circuit judge on November 2nd.
Judge Dickinson.
Carroll and I agree about one thing. There's only one issue in a race like this, and who's the most qualified by experience and training to be your next circuit judge. I chose a judicial career 16 years ago. I made the decision then to give up my private law practice and have a judicial career. It's the natural progression of that judicial career to go from district court to circuit court. If you don't have any judicial experience, you have to think up a reason why people should vote for you for this. My opponent has come up with several unique things. That shows that he is a pretty good trial lawyer. He can try to change a sow's ear into a silk purse, but it just won't work. Let me explain to you what I'm talking about. He has had an advertisement in the paper and on the radio that he thinks the most important thing, most important attribute of a good judge is being a good listener. Ladies and gentlemen, I want to tell you that there is a whole lot more to being a good judge than being a good listener. You need to know the law. You need to apply the law fairly to everybody without regard to their position or politics. You need to be innovative. You need to do things to make the system work. You need to be the example in the system that other people follow. You need to set the example by hard work and showing other people the way about what they ought to do in court. You can't let somebody else run the court system for you. You've got to be in there running it yourself. And you've got to make it work. If the judge doesn't work and the judge doesn't make the decisions, the system breaks down. Now, I've been doing this for 16 years. I've done these kinds of things for 16 years. I've watched the district court in the 43rd District grow from 5,000 cases to over 8,000 cases a year, the fourth busiest court in the state. You can't gain that experience overnight by having the governor call you on the phone and say, you're a judge now. You don't have that kind of experience. And you can't say the most important thing about being a judge is being a good listener. That didn't work. Then Mr. Redford said, well, I was judge of the Glasgow Police Court, and that's about the same thing as being a district judge. Well, it's not. It's not anywhere close to being what we do in district court. I was in the Glasgow Police Court for 4 years as the prosecutor. We did it about 20 minutes every morning, up to a half an hour, and we handled the whole caseload. It was drunks and disorderlies. That's all we did there. We didn't do juveniles. We didn't do probate. We didn't do civil. We didn't do small claims. We didn't do domestic violence. We didn't do mental cases. We didn't do child support cases. We didn't do paternity cases. All of those things that are in my jurisdiction as the district judge. Well, then you say, well, I'm a people person. Then you list all the things that you've done in the community. I have the same kind of list that he does for things that I've done in the community. I'm a people person also. I've had 100,000 cases come through the district court since I've been presiding there, and I've dealt with lots of people. 90% of the people that have any contact with the court system come through the district court. I've dealt with people for the 16 years that I've been on there. The final one that he says is, well, I've had a lot of trial experience. I want to tell you, before I went on the bench for the 8 years that I was a partner with the law firm of Richardson, Barrickman, and Dickinson, I believe that I tried more cases than anybody at the bar. I regularly practiced in 14 different jurisdictions. I knew what a judge could do and what a judge shouldn't do because I'd watched judges all over South Central Kentucky. That's why when the position came up to be district judge, I decided I'm going to try to do this. I believe I have an understanding of what a good judge can do, and I believe I have something to offer. If you don't have the judicial experience, you have to do it some other way. Judge Redford does not have any judicial experience. I've tried more cases as a circuit judge, specially assigned circuit judge, than he has. I've done murder cases, robbery cases, burglary cases, land disputes, divorces, all of those kinds of cases as a circuit judge. All right. I've done those as a circuit judge. I've had that kind of experience as a circuit judge. I've had more experience than he has at that. But it's all of that experience that's the kind that trains you to be a judge in the lower court. And in addition to that, I've had training in the classroom. Have over 700 hours of training as a judge at the National Judicial College and at the colleges that they're held annually in this state. I've been to all of them, and I have that training. I ask for your vote on November the 2nd. Thank you.
Ladies and gentlemen, I think the citizens as a whole owe a debt of gratitude to WCLU for broadcasting this so that you can learn of the issues that are involved in the various races, and you also owe a debt of gratitude to the Glasgow Electric Plant Board. You should be proud that we have both of these institutions in the county. It has been my pleasure to preside at these 4 sessions and interviewing candidates, and thank you for your attention. Good night.
Our county attorney, Ben Rogers. 6 years working for you in the county attorney's office, which ranks in the top 20 in the state in child support collection. Ben Rogers, committed to prosecuting drunk drivers and working for business. Ben Rogers, on the job, working for you. Re-elect an experienced leader. Ben Rogers, a county attorney you can depend on.